All right. Getting near the end. Quantetics. So this is an interesting one on what does ASA, or all or substantially all mean. Is it all your costs? Is it all your revenues? How do we determine whether we can claim all or substantially all? So as we know, all or substantially all is not really defined in the Income Tax Act. But CRA's interpretation is 90% or more. If 90% or more of your costs are related to SR&ED of a particular person, so someone, if 90% of their wages are SR&D, you can claim 100%. And the intent of that is if someone's really intended to be 100% R&D, they're probably not. They help organize the Christmas party, or once in a while they have to talk to a key client, or whatever. But they're saying everyone, even the head of R&D, is going to get sucked into some business issue or non-R&D issue sometime. But as long as it's less than 10% of their time, we understand we're going to let you claim 100% because that's really what that employee is intended to be, a pure R&D employee. What they did is they applied the ASA rules too to their costs. And what happened here is they said, well, the minister wanted to allow $345,000 out of $465,000 of total expenses. So roughly just under 80%. Because during the year they had to make extra money, the R&D wasn't cutting it, so they did, in addition to the R&D activities, they did exporting of firearms, arbitrage market opportunities, and services on duty, and whatever. And I guess that represented around 20% plus of their total time. So not the 90% or more. Now, so they tried to argue that still it was 80% solid or substantially all. And CRA's argument is 90% solid or substantially all. I would have said if the client was at 90%, they probably would have got there. But the real question is, what is all or substantially all? Because that's just a CRA in a paper saying 90%. The Act doesn't say 90%. And 80% is kind of close. So I'm saying this client might have even won had they been able to pull up the right cases. I can show you cases on other kinds of tax issues, like something called a standby charge, where if you have an employee benefit of your vehicle, and they say if you use it all or substantially all, 90% or more for business, it's a lower rate. Right? There's been people who went to court who only use it 81% of the time. And the court said, still close enough, all or substantially all. Because the Act doesn't say 90%. CRA says 90. There's cases where maybe 85% is enough. There's no right or wrong, but these guys didn't make the right argument on, 80%, I use 85% or above. That's my rule of thumb. 85% or above, I get a little more aggressive there. But 80%, borderline. He could have won, could have lost. They just probably didn't make the right arguments. All or substantially all is the opportunity, though. If any cost you can argue is 90% or more related to SR&ED, they apply it. So wages, same thing with the policy on materials. If the scrap value is less than 10%, you can ignore it, which is effectively the ASA rule coming in again. As long as the scrap or the proceeds out of it are less than 10%, claim all of it. All right. Some on the 18-month filing deadline. So we kind of already talked about this. Data calc research. We're going to talk about, or we've already probably talked about Alex parallel computers. As we said, the new rules came in that say you're not allowed to file a claim after the 18-month deadline, the filing due date of the tax return. But there's a section of the Income Tax Act, 220 sub 2.1, that says the minister is allowed to extend any deadline under the Act. Right? And this company was very successful, arguing that CRA can't write a paper saying they're not allowed to do it, because then CRA created a law to fetter the power of the minister. And it doesn't work. The minister tells the CRA what to do. The CRA doesn't make rules that the minister follows. That's the wrong direction. And the courts totally agree. CRA does not make rules for the minister makes the rules. So they would grant all these extensions every time. Yep, you file, get the ministerial discretion, goes through. They then passed rules after 2005 that saying minister can extend anything except the SR&ED. That's the only thing that the minister can extend under the whole Act after 2005. That still has not got royal assent. So again, it's proposed legislation. It's being applied right now by CRA as if it's law, but depending how aggressive you want to get, it's not technically really law yet. So if you go to court, you're probably going to win. All right, association status. So going back over here, association means control. as we said. If I control a company, then it has implications